Hey guys, thanks for joining. We're going to be talking about the discovery of facts about an injured person. This is also known as a 6B request. That's the biggest part. That's the biggest section here. So subsection A, 6A says, if requested by an insurance company, an employer must provide a sworn statement of earnings before and after the loss on a form that the insurance company wants. Now that only obviously applies if somebody's doing a lost wages claim. And this gives the insurance company the right to request that information and the employer the right to give that information, actually forces them to give that information so that there's no lawsuit from the injured person saying, hey, you invaded my privacy, okay? Now, that's only if there's a lost wages claim. Now, subsection B, this is the one that applies to medical providers. It's also called a 6B request. And it says every medical provider, I'm summarizing there, every medical provider, if requested by an insurance company, shall furnish a written report of the history, condition, treatment, dates, and costs for treatment, and why they are reasonable in amount and medically necessary. Reasonable, related, and necessary, right? Together with a sworn statement that the treatment rendered was reasonable and necessary. Now, that's a sworn statement, and it has to include language that says, under penalty of perjury, I hereby certify, blah, blah, blah. Also, the statute says that there's no patient privacy violation, no HIPAA violation. The medical provider must allow for the inspection and copying of the patient chart. You ever get that SIU adjuster in your office, and they say, hey, I want to see the chart? This requires you to show them to allow for the inspection and copying of the chart. However, I would argue, hey, you already have the chart. I mailed it to you. Leave me alone. There's nothing that specifically says they're allowed to go into your office and that you have to let them look at your files. There's nothing that says that. It just says that you allow them to inspect the patient records is the exact, let me double check the exact language on that, but it's just the patient records. Yeah, it just says records. And that could be, hey, I already mailed it to you, okay? You can't come in my office if you don't want to, all right? So that's there. It allows for that without there being a violation. A lot of doctors say, Abe, do I have to show them the medical chart? Like, do I have to give them records? Well, first of all, if they're from the insurance company, you already mailed it to them, so you already gave it to them, right? There's an exception for patient privacy when it comes to an insurance company. This is just an added sentence in the statute further authorizing that, okay? Now, in the statute, it says that an insurance company cannot do a 6B request, this stuff, for reasonableness of charges or medical necessity on every single case as a general business practice, right? They can't ask, hey, how did you come up with $50 for an adjustment or $1,600 for an MRI on every single case? They can't do that. They can ask for you on one case. They can't do it on every single case, all right? Subsection C, ABC, the right of an insurance company to sue for this information. They're allowed to sue for this information if they can't get it not consensually, okay? Subsection D and subsection F, I didn't put on there wasn't enough room. Subsection D, the injured person shall be furnished upon request a copy of all information obtained by the insurance company and pay a reasonable charge if required, okay? That's subsection D. They're not really that important. Just the injured person can get a copy of the records that the insurance company has. Subsection E, notice to an insurance company for the existence of a claim may not be unreasonably withheld by an insured. Notice to an insurer of the existence of a claim may not be unreasonably withheld by the insured, the patient. So then we're going to go to subsection F. The insurer must notify the patient and the AOB medical provider of exhaustion of PIP benefits within 15 days of exhaustion. Once those PIP benefits are exhausted, this section, subsection F, requires the insurance company to notify the AOB provider and the patient, all of the AOB providers, hey, the benefits are exhausted. No teeth to this, okay? No teeth to this part of the law, but it is in there that they must notify them. And then subsection G, an insured, the person who's named on the policy, whether it's the owner of the car or they're just named as a driver of the car, and an omnibus insured. Omnibus, think omnipresent, omni, all, right? If we're going to go to like Latin roots, Anyone who's covered, so that includes a resident relative who might not be named on the policy. That includes a pedestrian who's hit by a car. And that includes anybody who's going to get PIP benefits. So just a passenger in the vehicle. Anyone who gets PIP benefits must submit to an EUO, an examination under oath, if requested by the insurance company. Years ago, there was no part in the statute that said you have to go to an EUO if the insurance company requests it. There was just a sentence that says you must cooperate with an investigation of the insurance company. Some lawyer somewhere said, hey, it doesn't say anywhere in the policy or the statute this examination under oath thing, so we're not going, okay? And the Florida Supreme Court said, yeah, you're right. If it's not in the policy and it's not in the statute, we don't have to submit to an EUO. They put it in the statute now, so that's there. So they do have to submit to an EUO. I want to read you this important part about examinations under oath, because this is very important, okay? And this is super important, because the insurance companies use these EUOs as a tool to investigate everything under the sun. How did you find your lawyer? How did you find your doctor? You know, who are you living with? How did the accident happen? Some of that's reasonable, some of that's not. So I'm going to read you what the scope of an EUO is. The scope of questioning, and maybe I should go into an EUO. An EUO is an examination under oath. It's basically a recorded statement under oath, and it's usually in person. Nowadays, it's by Zoom. Used to be, you'd go into a lawyer's office or a court reporter's office. There'd be a court reporter, the lawyer or adjuster for the insurance company, lawyer for the injured person, and then the injured person. And so it'd be about 4 people in the room, and they'd ask questions about stuff. So it's basically like a recorded statement, but it's under oath, under penalty of perjury. So the court reporter types up everything, transcribes it. So this says, the scope of questioning during the EUO is limited to relevant information or information that could be reasonably expected to lead to relevant information. I don't know what that means, man. To lead to relevant information, think about PIP benefits. Compliance with this paragraph is a condition precedent to receiving PIP benefits. But just think about that. The scope of questioning during an EUO is limited to relevant information or information that could reasonably expected to lead to relevant information. How you found your doctor, how you found your lawyer, that is not relevant information. I instruct my clients not to answer those questions. I've had this one lady, that lady worked for Progressive and told my clients that they were not cooperating with the investigation because I told my clients not to answer those questions. We're litigating that case. I'm going to win that case. I'm going to make so much money in fees on that case. But that information is not reasonably expected to lead to relevant information about the bills, the claim. Okay, so that information has nothing to do with anything. Hey, what kind of we got billed for eStim. We got billed for eStim. Did they ever have a TENS unit in the office? Anything that did electrical stimulation? Anything like that? Oh, yeah, the electrocution thing, I had that. That's a reasonable question, right? Because they got billed for it. Hey, do you do exercises? They're billing us saying that they do exercises in your office with you. I don't do any exercises, man. I had a client who got billed for exercises and said, look at me. Do I look like I exercise? So always know that the patient can go to an EUO and the insurance company can ask them questions about their treatment. How did the accident happen? That's reasonable, right? Are they at fault for the accident? That's not really necessary in a PIP claim because it's called no-fault insurance, but I suppose they could ask about how the accident happened, right? But could they say, are you at fault for this accident? They could ask it. Doesn't mean the patient has to answer it. So any questions about EUOs, always refer back to that scope that I just mentioned. Thanks for watching.